Okay, I think it's about time to start. My name is Dara Hallinan. I'm a legal academic working at Karlsruhe in Germany, and I'll be moderating the panel. And we have at this conference and elsewhere numerous discussions concerning AI, and now we have legislation on AI. And it seems that the majority of these discussions and the majority of legislation focuses on trying to reconcile AI with fundamental social values. But what if it's not possible? What if this reconciliation isn't possible? What if it's the case that AI actually poses an existential threat to all or a set of fundamental social values? What if AI poses an existential threat to the rights to privacy and data protection? And that is the topic that this stellar lineup of panelists will discuss today. And in that regard, we have, in order in which they will speak, Fanny Hidvegi, currently Policy Director at AI Collaborative and previously a member of several significant bodies dealing with AI, including the European Commission High-Level Expert Group on AI. We have Zoe Karadasiadou, Legal and Policy Officer at DG Just, and prior to that, with numerous years of experience in various DP or data protection institutes, including the EDPB, the EDPS, and the Greek Data Protection Authority. Eduardo Ustaran, Global Co-Head of the Hogan Lovells Privacy and Security Practice, and widely recognized as one of the world's leading privacy and data protection lawyers and thought leaders. And finally, Bart van der Sloot, Associate Professor at Tilburg University, specializing in privacy and big data, and author of the recent book, Regulating the Synthetic Society. So Fanny, over to you.
Thank you very much. Good afternoon, and thank you for your persistence to be here at like 5:30. That's much appreciated. I'll talk about 4 things to start the conversation. What is an existential threat and why I got almost a heart attack when I first read the title. Second, how we should think about existential threats in the context of fundamental rights. Third, how the AI Act measures up as a tool to protect fundamental rights in the context of AI, just very briefly, that could fill an entire day. And then finally, what can we do in the future? So first of all, about existential threats, I'm sure many of you are familiar with effective altruism, but for those who are not, it's a quote-unquote philosophical movement to use money in the most effective way, but it has very strong ties to eugenics, as some would argue. And it's not the right, or it's not an acceptable framing from a human rights perspective of how we see it. It's you probably saw the Sam Altman saga. Well, when was it? Last summer? I don't even remember. And how Microsoft came out as the basic winner of that saga and just cementing and reinforcing the concentration of power in that company. Another key aspect of effective altruism is the link with long-termism and the existential risk. And here is why we're talking about existential threats. It was a deliberate, funded approach to change strategy and to keep a conversation on those long-term threats instead of the harms and violations that take place today. It also misguided the EU negotiations and gave general purpose AI much heightened attention compared to all the ways states are using AI to kill people, to over-police people, to incarcerate people, and in the migration context as well. So hopefully this is not the type of existential threat we're going to talk today. And as a second point, I was thinking through in how many ways you can think of threats to fundamental rights in the context of AI. And I think there's an important distinction that might not make that much sense is is there a difference between a lawful use or an abuse? And there are many ways in the context of AI which are on paper lawful, and the AI Act created that situation or cemented it to be even worse. But actually there are some use cases that are incompatible with fundamental rights. No safeguards can mitigate them. Nothing makes them okay. And as a society, we should be okay with not allowing that to happen. And that's why the only solution to those situations are bans and prohibitions. And there's nothing radical about bans and prohibitions. And that's why we consider in the AI Act, at least, it's a level of win that to some extent there are prohibitions. The next layer is whether something violates an absolute right, and that's something we haven't really touched upon even in EU law, the freedom of thought versus freedom of expression. We never fully explored that in the context of social media. Then the next layer is whether something infringes the essence of the right. And the essence of the right, the jurisprudence is not very elaborate except for in privacy and data protection. So that's a guiding jurisprudence and theory that we could use. And then finally, the last bit of how we see threats in the fundamental rights context for AI is that it's a failure of our international human rights norm system that it's so individualistic, and it does very little to protect from the collective perspective. So moving on to the AI Act, is it a win or a failure for fundamental rights? And with my previous affiliation as Access Now, and also in my personal capacity, I think it's fair to say that it's almost a complete failure, with a tiny bit of fig leaves of measures on fundamental rights impact assessments and some transparency tools in there, and the fact that there are prohibitions. But generally speaking, a law that has a risk-based approach is insufficient to protect fundamental rights, including privacy and data protection. And to link it to data protection in particular, no matter how much gymnastics the European Commission and lobbyists have tried to do, the GDPR is not a risk-based legislation. It has risk-based elements in data protection impact assessments and data breach notifications, but it ultimately is a very different type of law than the AI Act. The complete different standards for for how European technology can be used outside our borders is something that's completely unacceptable. And not that the European Union has much credibility these days on this international fora, but the AI Act is also problematic in that regard. And finally, on this point about the AI Act is the prohibitions, which again, we like the idea that there are prohibitions, but they're extremely weak. They still allow probably the worst use cases. There is a blanket exemption on national security, and there are sweeping exceptions on law enforcement, migration, and border management. To give you a very specific example, emotion recognition and biometric categorization systems are prohibited, but only in the workplace and in education settings, not in migration, not in law enforcement. If something is harmful, if something violates your right in an education context, then when you're at your most vulnerable stage at the borders, how that can be okay? And the answer to that is not legal, it's political, because this is ultimately about power and not about technology. And whose rights are we protecting? And as long as those who are in power, those are not the ones who are negatively impacted by technology, none of these reformist reforms and none of these policy tools will be a sufficient response to protect their fundamental rights. So what can we do? Change the attention on existential risks of today, of communities of color, of marginalized voices. There is a narrative change. We cannot let big tech take the lead and focus on this long-termist risk. We also need organizing power, because these institutions, no matter how much we would like to believe in them, they will always just defend the status quo. Within the existing structure, right, because we have to operate, most of us in Brussels, and that's not easy to change. The next step is the high risk and prohibition categories, and to make them work as much as possible. There are the scientific panel, the advisory group, to make sure that the right people are on it. And a long-term vision question I always ask: better fundamental rights and human rights legal basis in the EU treaties. So if we can organize around opening the treaties, which politically I'm not sure how good that would be, but there is a strong gap. All of our laws that try to protect fundamental rights are some kind of a combination of data protection and the single market. The single market is not about human rights. We're just trying to shape it in a way that it somehow does improve the situation. And lastly, in the US context, is no matter what the FTC achieves, and the FTC is doing much better than some of our competition authorities in Europe, they really abandoned the idea of national champions, while the European Union was very adamant to protect German and French interests during the negotiations. Without a comprehensive data privacy legislation in the United States, no AI policy can work. Data protection is not enough, but that should be the starting point in the US. Thank you.
Hello. So I'm the second one in the row. I must say that with Fanny, we have points of agreement and disagreement, as you may expect. So when I saw this title of the panel, whether AI poses an existential threat to privacy, my short question, as you may expect, is yes, unless we have safeguards in terms of regulations or other mechanisms in place that we can address these threats. And indeed, in the EU, since we have also a long tradition in regulation, we have a regulatory framework in place, which the short answer is, in my opinion, is capable of setting guardrails in order to make the existing threats not become existential for now and over the time. And of course, it has always to do how we apply the rules. What Fanny said, for instance, which people are going to participate in the panels for the next few years, because they have a certain mandate in the AI Act. So, and having said that, in the EU we have two legal frameworks that aim, and I think they are capable to address these threats in a manner that makes the threats non-existential. And I would like here to begin with the data protection framework, which also was the first used to address cases all known to you, like ChatGPT, and where the DPAs, they became also the de facto regulators, also in the absence of other oversight bodies dealing with that. And there we saw that the current data protection rules are capable of addressing these issues. The case and enforcement actions by the DPAs are still ongoing, but you have all followed how this has evolved by the Italian DPA that banned the ChatGPT, and then OpenAI was also forced to provide changes. I think the next speaker is going to speak about that and the various principles and whether they are challenged or they challenge AI, but which is the other side of the same coin. But indeed, I do believe that the current framework, data protection framework as we have it, is in place to address new phenomena, therefore it's also technology-free, provided that we apply it in a more, not flexible way, but in a way which adjusts to the context. To give you, to give you an example, we have, of course, to discuss what means data accuracy in a context of a, let's say, generative AI, where you might not be expect to become a full accurate data set about a situation. But you may still expect that if the prompt is, what do you know about Zoe Kardashiado, that this information is still correct. And what are the rights that you may then exercise? And indeed, there are avenues to exercise this, as the current enforcement actions, again, by the DPAs in the case of the ChatGPT could demonstrate. And now, of course, the next big legal framework, now the AI Act. The high-level expert group that created the ethical guidelines, and Fanny was a member of that group, pointed out to 7 guidelines that needs to be adhered. Why? In order to address the threats which can become existential to what is our perception of how society should work. So, these principles, they start with the human oversight, with human agency, transparency, cybersecurity, robustness of the system, and up to accountability. Now, how are these principles considered in the AI Act? Fanny has already talked about the prohibited cases. So these cases, for instance, are there to ensure that we don't have associated disruption that will, threaten our existential perception of how we perceive society, democracy of law, rule of law, and democracy. Then we have the high-risk systems, but we can say this is not enough. However, there are a lot of use cases therein, but the cases alone are not isolated. There are a lot of safeguards. How then providers of high-risk AI systems should prevent any unintended risk that goes beyond what is acceptable. And therefore, we have the several requirements in the AI Act, be it on data governance, be on the technical documentation, be on providing transparency to the downstream providers, and providing tools to exercise human control by the deployers of the system. This shows that we cannot only isolate and say the AI Act does not provide enough. We should see the whole framework of rules when they all are applied together in a good manner, then the risk can be prevented. So we don't have a solution that automatically will prevent any existential threat. And then you have also other procedures in place. You have strong coordination and alert system exactly in order to prevent and address risks that were unforeseen when an AI system has been put into operation. And you have a governance system with a strong centralized enforcement, which also help that any adverse effects are simultaneously addressed throughout the EU. And we don't have, different treatments. You also mentioned the fundamental right impact assessment, and there I would like also to say there are also other obligations for the users. We have the standards, and why do I mention that? Because the standards are going to further specify some of the currently more high-level requirements, and you have the codes of conduct and practice. And as the high-level expert group on AI has pointed out, there are three means to ensure a trustworthy AI: law, standards, codes of practice, and conduct. And to these three main areas, the AI Act has provided a response. Of course, there is nothing set in stone, and we have a long way to go. But this was also the same with the data protection legislation. We have this in place more or less since 30 years, because the principles have not changed under the GDPR. We see that we can evolve and we can address the risk, at least not to make them existential. I repeat that. And a final, not to make them existential for us, and not to deprive the right of its own essence. Here I use Fanny's reference to the essence of the right, although legally speaking, we will speak about the essence of the right when there are laws that may deprive the right of its essence, and not a technology that deprives the right of its essence. So, indeed, at least in the EU, although we can speak about the autopoietic aspect of the law, I would rather say is that the law captures phenomena, of course comes after the phenomena are in place, tries to address, and in the beginning, it's always the precautionary principle that prevails. So the law normally takes a more, let's say, defensive or, let's say, offensive stance in order to be able to capture phenomena that they are still not very well known. And the same we have in other product safety legislation, and therefore we have also the strict liability regimes, etc. So I would like to close, first of all, with an optimistic note that we are not doing that so bad.
Well, it seems like an interesting debate so far. And I wanted to address this issue from a slightly different angle, which is the one I'm familiar with because it's the one I see. And for those with an eagle eye out there, you will have seen that instead of approaching it from the point of view of how AI poses an existential threat to data protection, what I'm seeing is how there are existential data protection challenges for AI. And by that I mean how to ensure that when developing AI, when using AI, one can be reassured that that is indeed in compliance and that there are aspects of data protection law that can be overcome and can be respected and addressed in a way that doesn't make AI unlawful or illegal or, in fact, inviolable. And when we look at some of the principles, some of the basic principles of data protection law that have been around for literally decades, I think we can see how they are challenging AI. When you look at lawfulness, we all know about the grounds of lawful grounds for processing. When building AI, the reality is that there is only one possible lawful ground available: legitimate interest. Legitimate interest needs to be that ground on which we can rely in order to collect data, train a model, use that data to test the model, refine it. If we approach legitimate interest in a narrow way, in a way that we've seen in very recent times, where you say, well, a commercial use of data surely cannot be a legitimate interest, or maybe cannot meet the balancing test, then that is a real existential challenge for AI. Transparency is another tricky one, because when you are talking about the use of data, potentially scraping data from all over the internet, all over the world, all over our digital existence, and that data includes personal data, how are we aware? How can we be aware of the fact that our information, which is out there on the internet, but is being used in order to build AI, and what efforts need to be made to make us, every single one, aware of that? There is also another challenge around the fact that if there is one thing that I think we probably all agree in terms of AI, is that it needs a lot of data. It needs as much data as we can possibly collect. And AI models are being built on the back of so much data that you would think, well, how is that compatible with a principle that requires that data must be adequate, must be relevant, must be necessary? Is all this data truly necessary? How do we demonstrate that? How do we ensure that? Something that we've seen being challenged in very recent times, and I'm sure there'll be discussions at this conference about it, is to what extent accuracy is a factor, particularly in generative AI or any decision-making tool that relies on AI. When there is a principle that is requiring that the data process must be accurate, the output surely is part of that data processing that should be accurate. When we all know that AI, like humans, is intrinsically inaccurate. We also have the right to control how our data is used, the right to erasure. And yes, tools can exist in terms of how we control, for example, our interaction with AI and how much our own interaction with AI is used to train a model. But what if we exercise that right when the model has been trained? Can we expect an AI model to be detrained, to unlearn what it has learned? I don't think that's how the technology works. And I think we need to find a way to make that compatible. Oh, I think we've lost the presentation. Oh. And finally, I wanted to refer to perhaps the most important one of all in this context. AI is all about decision-making. Ultimately, it will be the tool used by all of us to make decisions, some very trivial and some very, very important. And when we have a principle and a right to limit how automated decision-making is used in order to determine truly essential and significant matters of our lives, how can we do that when with that tool exists? And the reason why I'm posing all these challenges that, again, we've seen for a little while already, is not to create an impossible problem. I don't believe that these are impossible issues to resolve. I think for our own sake, we should try to find a solution. AI is not going to go away in the same way privacy and data protection is not going to go away. We need to find a formula to make these things compatible. Where we land is up to us, and I think this discussion with every possible brain engaging in the debate is important. But ultimately, I think that if we're talking about existential threats, it's just existential threats to us as individuals, whether it is AI or whatever. And the way in which we resolve this existential challenge for the use of AI is, I think, by ensuring that we apply some realism as well, but some legal knowledge as to what these principles are all about and what they are trying to achieve. Thank you.
Thank you so much all for coming and attending this this panel. It's a real honor. It was already briefly mentioned, but if you're interested, I wrote a book, Regulating the Synthetic Society. You can buy it, but you can also download it for free. I think a QR code can be shown. If you're interested, it's just for free. Feel free to share it with anyone you want. And you just get the PDF of it. You can also go to the publisher's website. And I tried to kind of lay out what AI is, but also all these legal challenges with privacy and data protection, but any other right, basically. And I think all rights might be affected by AI. So as to the title of this panel, I think, to be honest, privacy has been declared dead like before it was invented. And that says something, because it's every time the loss of privacy that creates lawyers or others, regulators, to respond to that loss. Like Warren and Brandeis, for example, they responded to the rise of new technologies. And then in the 60s, 70s, databases arose. And then you had the Fair Information Principles, the resolutions of the Council of Europe, et cetera, et cetera. And now we're in this new domain with AI, and probably we will lose privacy, but there will be a response from regulators, and we might actually strengthen privacy and get new rights and new regulatory framework in response. So, being the last in the panel, everything has been said, basically, so I'm not sure what to add. I will maybe touch on 3 points. Personal data, the scope of that, the data quality principle, which has already been discussed a bit, but I want to elaborate on it. And finally, the household principle as well. What we should or should not do with that. So personal data, it's pretty clear that there are several issues with AI. One is, and this is an old discussion, the post-mortem privacy question, right? Do deceased people have a right to privacy and data protection? And in principle, no, the GDPR says no, you don't. There's always been questions around it, but now with deepfake technology, you can bring deceased people back to life. There are even apps that allow you to bring back to life a deceased partner. Now, do you want that as a partner? Do you want to speak at your own funeral, for example? Do you, as an artist, want to be brought back to life by your relatives, your children, to give concerts around the world, or would you rather not? So we might want to think about that, and we also might want to think about the rise of non-existent persons, right? You might have seen and heard the recent OpenAI voice chatbot, right? Very realistic AI assistant with a voice that giggles, etc. It's hard to distinguish that from a real person. The same applies to if you go to thispersondoesnotexist.com, but there are many other websites you could go to who produce these highly realistic images of non-existent persons. Now, there's one question to what you can do to non-existent persons. Like, can you generate porn with non-existent persons? Child pornography, maybe even, or not? Should there be moral limits on that? And a question that will be a bit more advanced is the development towards what is called sentience, right? A self-understanding of these AI models. Now, this is a territory that is part of fierce debate right now. Will sentience ever happen, or is this an illusion? But if it happens, then we might think that we should give rights to these AI models as well, if they're sentient and artificial general intelligence arises. The second point I want to discuss is the household exemption, right? And so for deepfakes, for example, it's difficult to estimate, but there are some calculations that almost 95% of all deepfakes online concern non-consensual porn about women, right? So this is the main use of this technology. It's also often said technology is neutral. This is not true. It's developed, the term even arose specifically when nudes, fake nudes of Taylor Swift were published. So this is still the main use of this technology. Now the problem from a data protection point of view is that when a person does so behind his computer, the household exemption applies, right? You cannot, in principle, tackle that issue of generating a deepfake nude by someone else. So this is already a problem, because if a neighbor knows her other neighbor, boy or man, is generating deepfake nudes of her behind his own computer, that might be highly uncomfortable. And the additional problem is that with a click on the mouse, it is spread online on these dodgy websites or social networks. And then these deepfakes can have a huge impact on women, especially on younger girls growing up at high school, and they're already used a lot right now, can have a huge societal and social impact on these young girls. And you're too late when they're already published. I'm not saying like what is published online stays online. There are ways maybe to get it offline, but it's very difficult. And it's also very difficult for law enforcement organizations to find who did it, because the website might be based in Thailand or wherever, and just finding the IP address of the person that posted it is not always clear. Right? So should we maybe limit the household exemption or not? Because if you do that, it gives the Data Protection Authority the right to look behind your door and what you're doing behind your computer, right? Do they have the authority for that? Do they have the capacity to do that? And is that maybe a cure worse than the disease? It may be generating more problems in terms of privacy. I don't know. The same as with extending the scope of personal data to non-existent people. There are also clear backdrops from that. So, and I have 2 more minutes, so I will move to my last point, which is the data quality principle. So very brief. AI is everywhere now, right? And so they are in photo cameras. There was an incident when you took a picture of the moon at a blurry night, the moon still came out very clearly because the photo camera is AI operated, and the AI system knows between brackets that the moon looks bright. Or when you photograph forests which are burning, it still comes out green because the AI, between brackets, knows that forest should be green. If you video call with people, your skin tones are automatically equalized, right? And the higher pitch tones are filtered out. So there's a lot of AI manipulation going on, these very subtle AI manipulations, in addition to real deepfake technologies, etc. So some estimates have it that in 5-6 years' time, more than 90% of all online content will be affected by AI, often very marginal, but sometimes also very significantly. What do we do with the data quality principle in that area? What does that mean to have correct and authentic data? Is AI generated data by definition in violation of that? Is it in violation if I, myself, manipulate my own photo? For example, politicians sometimes do that to make themselves more friendly or younger or what have you. Is that already a violation of that principle, or does that go too far? The data quality principle is inherently vague because it's unclear what needs to be established by whom at what point. So if I say, I feel like a woman, for example, but my passport says I'm a man, and the data controller wants to process my data that I'm a man. Who is right in this respect? Should I, as a data subject, have the authority to say what is right or not? Should the data controller, is there an objective reality, and who determines what is the objective reality? So that's also my last famous quote. So these are all, these 3 questions I touch upon in my book, but there are many more to which I don't have the answer, but I think we will need to discuss as a community broadly.
Thank you, all of you, for some really very thought-provoking contributions. So I'd like to kick off the public discussion by asking a question of my own, which each of you has touched on tangentially, but hasn't met head-on. How useful is this concept of an existential threat to privacy and data protection? Does it really bring anything to our discussions of AI policy or law? And even if it does encapsulate something useful, are there not maybe better concepts that we already have that deal with the same thing? So Zoe, you and Fanny, you both mentioned the idea of essence. So I'd open that up to all of you. Or one of you.
To me, it can have a use if we can reclaim that term, just like to reclaim the term of safety. You know, safety should not belong to the effective altruist community and to big tech. So yes, because as I said at the beginning, there are existential threats. People are dying, people are incarcerated, people are over-policed, people are pushed back illegally, people are discriminated against. These are all existential threats to those human beings. And so if that's just a narrative change, then yes, we should just claim that term back.
Okay. Anyone else? Nope. Then I'll open up discussion to, or open the floor to the audience. We have 2 people there, I think. Yeah.
Yeah, thank you for your comments. I have 2 short questions. I think in the beginning you have given a nice example on emotion recognition and biometrics. And it's true what you have said, that one of the problems is how to shift the power. I mean, at least to balance the power between those who are affected versus big companies and etc. And the question is how actually to try to balance this power. So that was my first question. And the second is regarding the inaccuracies, intrinsic inaccuracies of AI output. So of course these are inherent, but how would you compare this to human errors? So for example, in the medical field, so AI system output may misdetect some disease, but the same can happen by physicians, right? So my question, with the same level of errors, is whether the patient can accept an error made by the patient versus accepting it from physicians.
Do you have specific speakers in mind?
Yeah,
Fanny,
so for the first it was, yeah, the first speaker, and for the second it was the third, yeah.
Accuracy versus human error.
Yeah, that was the second.
Okay, the question, we're trying to establish the premise of the question. I believe it's about the accuracy principle. Is that right? The issue about, when you look at the, I think you were touching on data quality as well. Accuracy is all about making sure that the processing of that you're processing accurate personal data. The point I was trying to make is that technology, particularly in these early days, let's say, these early days, particularly of generative AI, where everything is being tested live, we have all probably witnessed, if you've used generative AI, you will have witnessed the fact that the output is not always accurate. It may be very impressive, but it's not always accurate. So to me, in a sense, that's part of the humanness of technology. In reality, as I said, AI is intrinsically inaccurate because humans are we are intrinsically inaccurate. So if this is a way of trying to say we cannot approach these principles in an absolutist way, in which we leave no room for error, no room for maneuver, because very quickly we get to a point where we can establish that there is a breach of a fundamental principle, which is probably not the right outcome. The right outcome is to ensure, first of all, that there is an understanding as to what the tool is for, on how it is used, and to what extent the decisions made by a tool or humans relying probably quite blindly on the tool are the right decisions. So I think there is a lot of nuance there as to how you apply the accuracy principle to AI technology, taking into account, again, the human side of the inaccuracy, which I think we should all acknowledge.
Thank you.
Thanks.
Here, I mean, maybe we should distinguish a bit about, between the accuracy as a requirement under the AI Act and the data accuracy under data protection law. These are not necessarily coincide. And what do I mean? In the data in the AI Act, accuracy is how, I mean, whether the data are accurate and to which degree for an intended purpose. This means that different metrics or different rates of accuracy could apply depending on the scope of application of the AI system. And this is easily to understand because there are, anyway, systems that they are of low risk and they are not even regulated under the AI Act. There we can accept even higher or high rates of mistakes, and there are critical areas where the rates of mistakes are low and must be low. In fact, this is nothing new because we know this from all the safety legislation. And I give as an example the medical devices legislation. There the accuracy rates, depending again on the specific application, are normally high to very high. And when you say accuracy in relation to human error, there is also something that is inherent in the AI Act as part of a product safety legislation. This means we always have to consider whether the benefits of using something outweighs also the risks. Meaning that if, let's say, by using that, the human errors rate are minimized, then the use of an AI system can be acceptable as such. This does not mean that we use it without human oversight, because it's another requirement. So, and on the other side, if the let's say the human error by doing something manual is minimal, and by the AI system does make more mistakes, I mean, this is let's say, a proof that the AI system is not fit for the purpose. All these are considered in the AI Act. Now, the data accuracy as a data protection principle requires that the data are accurate and relevant, again, for the specific purpose of processing. This means also here, maybe we don't have absolute terms, as the right itself is not absolute. We don't have absolute requirements on what is accuracy, but it must be also considered in the specific context of processing.
Fanny, I think the first question was mostly directed at you.
The power one, an easy one. Yeah, so I work for a philanthropic organization. So personally, I think my job in that is to fund organizations that do the outsider game, because we are very familiar with the insider game in this room, and to have any change in power, there needs to be a radical change and radical action. But am I going to bring that? No, but maybe I have resources to support that. Then concretely in the AI Act, there is a tiny hope in the transparency measures, and there is a future action on investigative journalism, freedom of information requests, research that at least can help us start somewhere. On the monopoly of violence problem, I don't think I know the answer how to change that. One particular answer that many people are working on these days on this power imbalance, but it's a dangerous one. It's about public interest AI, and how by public investment together with private investment, we can quote unquote democratize access to data, compute, and talent, which is an option, and we should investigate and try to do that. But we've also seen how digital public infrastructure can be co-opted and can be used for mass digital ID systems and other really harmful things. I'm afraid I can't do better on the spot on this.
Thank you very much.
So I think there were some other audience members who had a question. I think there was a question a couple row forward. Yeah, there we go.
Hi, Giancarlo Margeri, Leiden University. I have two questions. One is about how do you see regulatory sandboxes in the AI Act as a potential added challenge for this existential problem or a solution? The second, connected to this power and politics discussion that Fanny was making, Article 7 of the AI Act gives instruction, well, let's say discretionary instructions, to the Commission to update the high-risk list, including mentioning of power. But how, and maybe this question is for Zoe, how discretionary is Article 7? So is it based on political will? Is it more, administrative implementation, case-based? I'm curious, I mean, maybe we don't have the answer, but I'm curious about your view on Article 7. Thank you.
Okay. Would anyone like to field the first question about sandboxes?
So, as regards regulatory sandboxes, I think in my taxonomy is also a safeguard. Why? Because there, you have the opportunity to test and new products, new implementation. And as it says, both to, in order to achieve more legal certainty and in order for the public authority supervising them to achieve more learning experience through the sandboxes. So the sandboxes itself does not appear to be a challenge. It is also a means to ensure more trustworthy AI. Of course, now it is a question how this will be implemented and whether there will be sufficient broad sandboxes to be able to accommodate various projects. So the challenge is for the member states to provide all the necessary resources for the sandboxes. At the Commission level, I mean, if you, in the AI Act also provides that it can be also a coordination of the various sandboxes so that also stakeholders can approach the national sandboxes. Plus that various stakeholders, civil society, etc., must be also included in the sandbox, which is another aspect why the sandbox can indeed rather work as a safeguard than as a challenge.
Anyone for the second question? 7.
Still on the first question or in the second?
If anyone has anything for the first question, please. Otherwise, we move to the second question.
Because he looks again to me.
Because it's about Article 7
No, I mean, it's about Article 7, but I think that we need to look at exactly. I think it is not, it cannot be, and the executive does not only act on discretion like that, on arbitrary discretion. The discretion must be a legitimized and a lawful one. So when the conditions of Article 7 are fulfilled, then an action should be taken. Of course, the discretion plays a role, whether it is now opportune to intervene, to change, or maybe later on. It's like taking an enforcement action or not. But, and therefore, in this procedure, the Commission is not alone. It receives input from several parties and stakeholders that they are, already named in the AI Act. Plus that, it has also monitoring obligations through the AI office. And this should be also not violated, because this will fit also in the amendment of the annex.
Perfect. Okay, I think we had a question at the very front. Then, okay.
Hi, Mark Rotenberg with the Center for AI and Digital Policy. This was a great panel. Eduardo, I think I'm going to assign your table trying to show the data protection challenges to AI. I do want to say that we tend to use this term AI in a narrow way to apply to what we've seen over the last few years with the machine learning data intensive models. It was not always this way. We've had rule-based AI expert systems that were transparent and accountable. And I think it's very important to keep in mind that AI doesn't necessarily require data collection. It's a choice that's made in some systems and some deployments, and we need to get away from the deterministic assumption that this describes all of AI. But on this point also, and this is my question to the panel, it seems to me that one of the big challenges that was set out by the former UN High Commissioner for Human Rights, Michelle Bachelet, is how do we ensure that AI systems do not violate international human rights? Because if they do, they should not be permissible. And you have within the AI Act some of the tools to address that challenge with some prohibitions, imperfect, not as far-reaching as we hoped, but nonetheless established now in a comprehensive regulation. So my question to you is, how do we give meaning to the legal prohibitions on AI? How do we treat seriously that impact assessments are a priori and may lead to the conclusion that a system simply should not be deployed, because that's how we understand impact assessment in the environmental realm. How do we make the AI Act as robust and as impactful as possible?
So, I think that's relevant for all of you. Bart?
Should I maybe say, thank you so much, Mark, for your question. I think you're perfectly right. This is a design choice and doesn't have to be that way. And to be really blunt, I think most current AI systems that are based on these huge data scraping initiatives are in violation of human rights. Data protection, privacy, intellectual property. Like, where is intellectual property? And these companies, they won't be open where they scrape the data, but we are pretty sure that they just scrape the web and got their hands on anything they could find, basically. And this is not allowed, point. So if we're really strict with the rights, we should not use any of these models, point, and prohibit them.
What I would add, about the point about the AI. Thanks for your very sharp comments and questions. Is that we have in Europe 30 years of background to data protection law. The AI Act hasn't even been officially published yet. So yes, we've been debating it since 2020, and yes, there's a lot of discussion. But the point I'm trying to make is that we've got another 20, 30 years ahead of us to learn how to apply the AI Act. So I don't have an answer for the question of how to do it in the way that you are referring to. But my guess, if European data protection law is anything to go by, is that you need to be able to adapt the law to the way in which technology is evolving, because that's what has happened with data protection. And sometimes you get it right, sometimes you get it wrong. But I think a very important principle behind European law, whether it's data protection or AI regulation, is that technology is always moving. The law is static in the sense that it's written and it's published, and then it has to be interpreted. But that interpretation cannot be static. That interpretation also needs to follow the technology with a view to achieving the intended outcomes of the regulation. And that is what we always, always, always need to bear in mind. When interpreting the law, whether you're talking about data protection law or the AI regulation, I think the most important thing is going to be over the next decade or 2 decades is to bear in mind what the aim of the regulation is, so that we can adapt that interpretation to the way in which the technology is evolving.
Okay, then I think we can move on. There was somebody at the front who's been waiting a very, very long time.
Okay. Hello. I have 2 questions. The first one is, should we review the notion of legal personality in order to permit to the family of a deceased person to entrust the data of the deceased person and the possibility of protecting it in order to avoid moral damage? And the second one is linked to the legal personality. For a non-existent person, you talked about it, should the legislator give it a legal personality, which will then be exercised by its inventor or the provider?
I guess I should take this. Thank you so much for this question. Well, I would give it back basically to you and to everyone. This is a debate we should have, and I think I'm pointing to clear reasons why this could be an argument. Because there are clear moral questions about other people using your data, your image after you're dead. I don't want that personally. I think it's clear that at least there should be moral limits on what you could do to or with non-existent people. Whether they should have rights, it depends, I think, on to what extent they are truly intelligent and truly sentient. I do want to say that this debate is now being discussed mostly in a black and white model. Like most people say, it's not yet sentient, it's not yet AGI, which is probably true. But it's a gliding scale of intelligence. It's a gliding scale of sentience. And I think the more AI will evolve, the more we will arrive at a point where at least it's impossible for us to distinguish whether an entity is a person or not, and whether an entity has feelings or it has not. Like, it will at least say that it has, it will at least give us the impression that it is sentient and has self-understanding, and there is no test to establish whether an AI model has sentience or not. Or to be more precise, we had tests the Turing test, for example. And AI has already moved beyond that. And now we're saying, oh, no, 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 can't be true. We're not there yet. So we're inventing new tests. But my prediction is probably in 2 or 3 years' time, it will pass that new test as well. And so this question will become like, okay, at one point, should AI robots or AI avatars or AI non-existent people have rights or moral protection of their own? And what does that mean if robots could vote, for example, right? Could they found their own robot party, for example, right? And this is probably, if ever, 20, 30, 50 years ahead of us. But it will, if happens, very revolutionary. And this steps into the debate of transhumanism. There are Silicon Valley people that say, actually it would be a good thing if AI entities took over the world and humans would move to the background or not procreate at all. Because what have humans done is fair war against each other, deplete the earth, and what have you. So actually it would be for the best. Well, this is a bit of an extreme position, but I think this question will become ever more, I don't know, do you know the Tamagotchi? Yeah, the Tamagotchi, for those who don't know, it was a little egg-shaped nothing, right? And it was pretend pet, basically. And you had to feed it and give it water. And then if you didn't, it died. People were crying when the Tamagotchi died because you go attached to an egg-shaped nothing, basically. Yeah, so this is already, and if you have a real robot that speaks and giggles like the AI, OpenAI voice assistant is doing now, at least emotionally, it becomes so difficult to not assign moral value to it. So this will be a question.
I think, Fanny, you wanted to make the last wrap-up comment?
This makes me just so angry. Like, I think I couldn't care less about the rights of non-existent people as long as we're not protecting the rights of existent people. And that's what I would focus on first.
I think that might be a perfect place to stop the panel. We are now out of time. I think we had a great panel with humans in the foreground, so at least for now, this is okay. All right. Thank you all for coming very much.